Okay, it's 12 o'clock Central. Welcome to the monthly webinar for the HR Hotline program. This month we are going to talk about everything you need to know about conducting background checks. We're going to talk about lots of things. We're going to talk about some state stuff too, but we're mainly going to focus on federal here. As with most months, my name is Kevin Mosher. Most months this is being presented. My name is Kevin Mosher. I'm a labor and employment law specialist certified by the MSBA, partner up in the Thompson Co. St. Paul office, and I'm happy to present to you this month. For those of you who have been regularly attending these webinars and the seminars that preceded them, I think this is about the fifth. I think we're right around the 50th presentation. I think this is officially the 50th presentation of this series. So we're going to celebrate it with a brand new format. Like I said, for those of you who are familiar with this presentation, you'll notice the format's very different. So it is the result of my new administrative assistant, who's a recent college grad, as well as our similarly millennial marketing team down in Dallas. They're bringing a lot of creative energies to this. So I am not wearing, tweed. I haven't grown facial hair. Not skateboarding to work or anything like that. But we're going to try something a little fresher. We'll see how it goes. And I think there is some sort of feedback request. I think I've got a poll later on, so let me know what your thoughts are. On the right side of your screen, you should be seeing that there are some questions. You are welcome to ask questions. If I have the opportunity during the presentation, I will stop and read those questions and try to answer them. Otherwise, normally I can get to most of them when there are questions, but if not, I'll try to put them all together and then email them out to people afterward. And I do welcome your questions if you have them. Okay, let's jump into it. Going to a user error is going to occur with this new format. Okay, so today we are going to focus on, we're going to start with the Fair Credit Reporting Act, which is the federal law that regulates consumer credit reporting agencies. It doesn't really regulate employers per se, but it does put some burden on employers to ensure that the credit reporting agency, a CRA, if you're into the lingo, that a CRA is doing their job when they're working for you. So there is some potential liability. So even though the Fair Credit Reporting Act doesn't specifically regulate employers, it does indirectly regulate employers. So we're going to talk about that. We're going to talk about Title VII, which is at the federal level. It is administered by the Equal Employment Opportunity Commission, the EEOC, and so we're going to talk about that. Background checks several years ago were really a hot issue, hotter than they are today, mainly because there's been so much at the federal and the state level that's been done to really curb employers from being able to use background checks and dissuade employers from using background checks in the employment hiring process. The number one weapon that they use to try to curb employers' enthusiasm for this is ban the box legislation. So we're going to talk about ban the box legislation as well. Okay. In addition, so I've mentioned the Fair Credit Reporting Act, the FCRA, Title VII, which is the federal law that prohibits employment discrimination for employees as well as applicants. With regard to various protected classes like race and national origin and gender and age and religion and that sort of thing. So Title VII, when we talk generally about Title VII, we talk about federal law that prohibits discrimination on the basis of hiring and firing and with regard to all other terms and conditions of employment. At the state level, we talk about negligent hiring, which is a common law tort. and could always be brought against an employer if, arguing that the employer negligently hired somebody. And we'll talk about ban the box. But, on the negligent hiring side, it's really one of those, damned if you do, damned if you don't situations where, on the one hand, employers open themselves up to liability by by hiring people who and putting people in a place to potentially commit crime or hurt somebody else. So the classic example, might be the classic example from law school, honestly, is a hotel hiring somebody and giving them, access to all the rooms, and then that person using the access that they have in their job at the hotel to like steal or hurt somebody, that sort of thing. And so, and I think there might be, well, anyway, so, that would be a classic negligent hiring situation where the person who's harmed would say, you know what, hotel, you really should have done more than to hire this person who has a bunch of felony convictions for theft or assault or whatever it is. And instead you just went and hired this person, you gave them the keys to the kingdom, and they were put in a position to hurt me. Therefore, you should be liable for my pain and suffering and medical damages or loss, other losses, that sort of thing. So that's negligent hiring. And so we need to be concerned that as employers, that when we are hiring people, that we are hiring people that are at least trustworthy, and that the access that we give to them doesn't put them into a great position to hurt somebody, or steal, or cause some sort of damage, unless we've done some due diligence on this to ensure that before we give them the keys to the kingdom, that they are at least trustworthy with those keys. And so the way that employers do this is by doing pre-employment background checks. You could do criminal background, like an investigative background check. You could do a consumer background check to determine, what their trustworthiness or something like that is. But we primarily, at the ban the box stage of this, we are primarily concerned with criminal background checks. And again, just like the hotel situation, should be concerned about the criminal background check as well. And if a criminal background check would easily find that somebody has a long history of working for hotels and hurting people or stealing from them, you're going to be in a pretty bad place legally if you are sued for negligent hiring, because it could have been easily found out that this person was, never should have been put in that position by the company. So that's just a typical example of a negligent hiring decision. So again, it's damned if you do, damned if you don't, because so many of these laws at the federal level and at the state level are increasing the prohibitions and the restrictions and threats against employers who try to do background checks. So, why do we want to do these? And I think I'm pretty sure that's Bill Gates. I don't know what he was arrested for, but he's a pretty bad dude. So anyway, I mean, why do we want to use background checks? One is, again, we could stave off these negligent hiring decisions. If somebody does sue you in that hotel situation that I had mentioned, if somebody were to sue you for negligent hiring, and if you had done a background check, you could easily just pull out the background check and say, look, we conducted a background check and nothing bad happened. This person doesn't have a past history. We had no idea. When we hired him, he did not say that he really likes breaking into rooms and stealing things from people. That didn't come up in the interview process. So and then we did a criminal background check and nothing came up. So there's no past practice. There's no history there. So we can stave off. So that's one reason why we want to do that. Again, here you can see the list, to get at the individual's character, to uncover past history, to avoid the negligent hiring, and discover lies on applications. Sometimes, it's kind of nice to, if you do it, you could find things where the person has lied to you during the interview process or the application process, and then it's best not to hire people who lie on applications. That just never ends up turning out well long term. So that's why we do it. We do it for legal reasons, to stave off liability, to mitigate liability and risk of these negligent hiring, and then also for morale and environment. It's not listed here, but morale, for environment, for culture, you just might not want to hire people who are convicted felons. Maybe you do, depends on your business model, I guess. But for the most part, I think most professional businesses probably don't want to hire convicted felons if the conviction is related in any way or could impute some sort of bad judgment or ruin goodwill in the community, that sort of thing that a business spends a lot of money and time and effort in developing. The problem is this, and this is where the EEOC at the federal level and state level and states getting into the ban in the box, this is where they are they're focused. The problem with doing criminal background, primarily criminal background checks, is that it could be a backdoor way of discriminating against people. And the reason is, there might be reasons, lots of reasons for this, and I am not a social scientist or criminologist or anything like that, but the facts are pretty clear that African American men and Latino men and women are disproportionately, particularly men, but women too, are disproportionately incarcerated. And I don't think that statistic is going to surprise anybody. There's been a lot of conversation about that over the years nationally. So you can see the statistics here on the right, and those statistics are a couple years old from the BLS, but because of that, and again, right or wrong or whatever the reason is, and I'm sure there are a lot of reasons, and every situation might be different, but for whatever it is, if as a company we are having policies that are going to conduct criminal background checks, and we're just going to say, like, okay, for this job we're going to do criminal background checks, and if we do that, then we need to be aware that we are going to disproportionately impact the people of color, that men and women that might be applying for the job, just because the numbers, because the percentages break down, that if you have this many more percentage-wise people of color that are incarcerated, you're likely, and then you use that as a criteria, you're likely to be weeding out a lot of people potentially of color. And so the EEOC, at least under the current administration, the next administration we'll see, I suspect they will take a different stance on this, but the EEOC has come out pretty strongly and said, look, just on its face, doing a criminal background check is problematic. And there are some, and then they say unless, and we'll talk about the unless criteria in a little bit here, but this is the potential problem, and this is where the advocates at both the state and the federal level have been gearing toward, where they've been arguing that if you're doing criminal background checks, you are essentially backdoor discriminating against people, which is in violation potentially of just as an impact level, it is a violation of Title VII, race and color prohibition, discrimination prohibition, and then many other state laws, just like we have in Minnesota and many other states that have human rights laws that similarly protect against discrimination, prohibit discrimination in the workplace based on race and color and national origin, that sort of thing. So this is the concern. This is the result of it. And again, we just look at the statistics, and it's not employers' fault that the incarceration statistics are what they are. But if it's become so disproportionate that your workplace, because you're using criminal background checks, becomes especially disproportionate to the population surrounding your business, if it becomes disproportionately Caucasian, or if it becomes disproportionately African American in a Latino neighborhood, it raises the eyebrow, I guess, or whatever, the flag of the EEOC, and it could be opening yourself up to a disparate impact type of discrimination claim from applicants. We'll talk a little bit more about that and what we call the green factors later on. Let me see. Somebody's asked a question. Let me see. So somebody's asked a question that what if there's a series of incidents or arrests but no conviction? Would that warrant a definite, like a definite no? And would it be, and if you still hired the person, would it be enough to avoid discriminatory, like charges of discrimination? And we'll talk about that a little bit in these green factors. That kind of gets into it, but where you've got a lot of arrest record, it's one thing, but for the most part, we don't, I generally don't advise putting a lot of weight into arrest record. The arrest statistics are similarly disproportionately heavily favoring, people of color, minorities in the United States. So it's pretty hard. It's pretty hard to argue that if you're just basing a decision on arrest record where there's been no conviction, and you're just across the board taking out people who have been arrested without looking at the situation in a more qualitative state, then it's hard to argue that practice on its face is not discriminatory. It's harder to argue than if you're looking at conviction, which again makes it a little bit easier for you. And again, depends on every job. We have to look at the nature of the job and what the nature of the conviction is. But that's what we want to do. We need to look at a qualitative, situation. So each individual applicant and their background check. We'll talk about this more later, but we need to look at each one of those qualitatively rather than just taking a broad stroke and just wiping away a lot of these people just based on arrest record, certainly based on arrest record, but even based on conviction history unless it's really related. So we'll talk about that a little bit more in a bit. So jumping into the Fair Credit Reporting Act, so I've kind of laid the groundwork for what the battle is. And what the situation this is difficult for employers. A lot of employers don't want to hire people with criminal backgrounds, but then they need to recruit as well, and that's difficult, and they don't want to get negligent hiring. So again, this is a pickle. I understand that. So let's look at just some fair credit reporting, what we need to do. So if we do engage a consumer credit reporting agency or a CRA, what we need to do is this, and a lot of you who use third-party vendors for doing background checks, they should, I suspect they are providing you with a lot of this documentation, but if they're not, you definitely need to get it from them. So you need to notify the applicant, or if it's an internal promotion to a job, you have to notify that person moving in through the promotion. You need to notify them that you will be pulling a consumer credit report and or an investigative report. So that's two different types, and so you need to put them on notice of it. The notice needs to be in writing, has to be standalone. A lot of job applications that I've seen over the years will have a this notice in writing that a consumer or criminal background check is going to be conducted on them, and they'll put it like in the bulk of a bunch of little language on the job application. That does not work. It doesn't satisfy the Fair Credit Reporting Act. It needs to be standalone. So if your job application right now has a little paragraph where the person authorizes and it's just all part of one big signature when they apply for the job, that needs to be gone. And a lot of you are probably in states where you can't have this, where you can't talk about criminal history on the application anyway. But either way, if you're not in one of those states and you have the writing, has to be separated. Standalone in writing. And then it's probably a good practice just to provide, if you're going to be pulling the background check, to provide the summary of rights under the Fair Credit Reporting Act. We technically don't need to provide that until we are notifying somebody that we are about to take an adverse action against them based on what we have found in the consumer report, the consumer credit report. But if it's just as easy, it's sometimes nice to just give them the summary of rights now so you don't have to worry about it later on. So that's what we need as employers. And it's not that, like I said before, it's not that employers are required to do this. It's that the consumer reporting agency can't do it they cannot give you that information unless you've done this. And so if then you don't get this, and your credit reporting agency should not give the information to you. So you know, that's they shouldn't be giving this to you. So as a result, you know, indirectly you do have to gather this for them. Investigative reports, a little bit different. They are a lot of employers don't do these as much. They're pretty time intensive and stuff, but you do need to notify the type of report that you are pulling for of these people. And so this is, you know, more like personal interviews to get the person's character, reputation, personal characteristics, and lifestyle. And again, need to notify the employee. And I don't know if anybody on this call actually knows Simon and Simon. I really liked that show long time ago. But anyway, they were investigators, and so that's where that is. Things to be careful of. Technology has changed, and with that change, it has become easier to figure information out about people. Now, the Fair Credit Reporting Act, the FCRA that we've been talking about, it does not govern, you know, if you're on HR, if you work for HR and you're going to check out, you know, LinkedIn or Facebook or I don't know, MySpace or Twitter or whatever, and you're going to go in and follow some people, follow applicants, see if they're, you know, if they're on Facebook, you know, and doing bad things or whatever, or on Twitter saying really bad things, and you want to count that against them, that can be okay. You don't. That's different than going to a credit reporting agency, right? So we're just looking on the internet and we're finding information about people. A lot of states, however, you know, kind of one of these employment laws du jour the last year or so, and maybe last 2 years. I think there have been a few, just, you know, I don't know what they were thinking, but there have been a few news stories, I don't know if they're even true or not, about employers who have requested, as part of the hiring process, requested that employees provide their username and login to like Facebook and Twitter accounts and LinkedIn and stuff like that, so that they go into the accounts and see everything that's been posted and all that. You know, I've read the stories about those. I don't know if they're true or not. It sounds too stupid to me to have actually ever occurred, but you know, there are those people out there, so you never know. But anyway, it galvanized several states to go and put prohibitions on employers asking for login access. I guess in the states that haven't passed those laws, I guess you could go and do it. I don't recommend it. But anyway, we have to be careful of that. So use of social media, we really should not be asking for login access, but you can go and look at Facebook and Twitter and stuff and see if people, if these applicants are, you know, doing stupid things. If we are going on social media and we're checking out these applications, these applicants, to see what they're about, the risk here is that we find out things about them that are potentially protected, like they belong to a union, they belong to a religious group, they belong to whatever, and it's protected by either the state law or Title VII. And if we then, now that we have knowledge that they belong to one of these groups, then if we refuse to hire them because of that, it opens up the door. It opens up the door for you know, a Title VII or a state Human Rights Act allegation that we violated those laws because we refused to hire them, or National Labor Relations Act, because we refused to hire them because they're protected activities. So buyer beware on doing social media checks. Got to be careful. We have to be careful on that when we get information that, you know, suddenly, I mean, there are reasons we don't ask for somebody's age on an application. We don't really want to know, and we don't really want to be accused later on of using that as a criteria for not hiring somebody. Similarly, you know, you probably would only be looking at somebody who you're about to make an offer of employment to, or if you've made a conditional offer of employment, you're probably not going to go on Facebook for everybody that's applied for the job. But again, we'll find out if you do it, and you don't know how old somebody is or what their race is or something like that, and you go on Facebook and you find them, well, I mean, you're going to get that information. So I'd be careful. I would not recommend going on social media and looking into people unless you have made a conditional offer of employment. There have been many illegal background check apps out there. A lot of them have been closed down by the federal government, but careful that if you're using a background check app, that you still need to, even if it says we're not a background check app, several of them have said that, and the Fair Credit Reporting, the Consumer Trade, no, the FTC, the Federal Trade Commission, the FTC, the Federal Trade Commission has found in many of those situations that the disclaimer language saying they're not a background check, a consumer reporting agency, that that doesn't cut it. That just because they say that, but then they're acting like a consumer reporting agency and providing background information, criminal background information, and all of that to third parties being the employers, that yes, they do need to comply with the Fair Credit Reporting Act requirements, the notice and the summary of rights and all those things that we went over earlier. So careful when using apps that charge very little money or whatever to pull background checks on prospective employees. If you are going to, so if you're a credit reporting agencies or a CRA, this is what you need to provide as an employer to them. You have to, notify them and get the authorization from the employee, and you basically have to certify to the CRA that you're not going to violate Title VII. So technically, the CRAs that are providing this information, they should not be issuing you anything until you have until you've received a signed written authorization from the employee and you've passed it on to them. So just more about what an employer needs to do with regard to that. Okay. Minnesota, I threw this in just for those of you, because I know a bunch of you on the call are locally here from Minnesota, so I just kind of threw this in so you could see that a lot of states have this where they say there is no requirement that you conduct a background check, and if you do, except in certain professions, and then if you do, here are the restrictions that you have. So in Minnesota, we have some websites that we can access. And then with some of them, the employer has to go through the steps with the employer, the prospective employee. Okay. So in any state at the federal level, if we are going to take an adverse action, we cannot, based on information that we receive through the Consumer Credit Report or information we receive from the Credit Reporting Agency, the CRA. If we are going to do that, we have to give notice in advance to the applicant or employee that we are going to take adverse action. And the adverse action might be we're going to fire you. The adverse action might be you're not going to get the promotion. The adverse action might be that we're not going to hire you. So we need to provide. A lot of employers do not know this, or they don't care, and I don't blame them, but it's a procedural step that delays things out, but you need to do it. And so if you're going to not hire them, for example, just because you don't like them or they gave a bad interview, even though you've done the background check, you just decide, hey, they're not a good fit culturally with us, they don't seem to have the skills, and you decide not to hire them for other reasons, then you don't need to comply with this pre-adverse notice requirement. But you do need to, if you get something in this report and it raises a red flag, and that is the reason why you have determined that they are not qualified to work for your organization, your business. So if you're going to do that, what do you need to do? So one, you need to give written notice of the intent to take an adverse action, and I suspect for those of you that if you use a third party, a CRA, they hopefully have this for you and can help you out. The two, you need to give a copy of the report to the person. 3, that information, the pre-adverse notice needs to have the name, address of and the phone number of the CRA, like Equifax or TransUnion, whatever it is. So it has to have all the contact information so that the applicant, for example, can then contact them to be like, hey, what the heck is going on with my report? We need to change this around. And then you have to give them a summary of the individual rights if you haven't already. So these 3 things need to go out to the person. Now, one of the issues that employers, before you're going to take an adverse action, one of the issues that we as employers have is, well, how long do you keep it open? And there's no set time. Like, there's no law, at least that I'm familiar with. I've never seen, never heard that says, well, you need to keep it open for X amount of days. You have to give the employee a chance to fix it with the with the credit reporting agency. And if you don't give that to them, then in that meantime you can't take the adverse action. So once you have identified something, you got to give them a chance to fix it. And that's true, but there's no timeline for it. And so this is a problem. So what we have to do is we basically have to use a reasonableness time gauge here, and we need to look at the nature of the job. So the FTC wants us to look at the nature of the job, the way that the employer does the business, what's the need. So needs versus the rights of this applicant to try to fix these things. And then courts have looked at these issues, and there was a decision several years ago in Minnesota basically talked about 14 days. That can be forever if you're continuing to hold the job open for 14 days while one of the applicants who's otherwise qualified for the job tries to figure it out and fix it with the the credit reporting agency. You could certainly in that time talk to the person and say, hey, look, are you is there a problem here with the CRA report? Is this an issue? Are you going to be contesting? If they say no, that's accurate, I guess I was lying to you, or no, that's true, well, we should have that conversation with them anyway. And if they're not going to contest it, I think you can go forward. But I think we have to look at this individually at every single situation, every single job, to make a determination as to how long we wait, if we wait at all. And part of that is having a conversation with the applicant to find out if it's true, if they're going to contest it, that sort of thing. I don't think you have to wait 14 days if they tell you right away and fess up to it, and you say, look, that's a real problem. It makes you unqualified for this job based on what we found in this record. I don't think you need to wait 14 days. As a matter of course, I think you should just have the conversation if they tell you that is confirmed true, and they're probably not going to be contesting it with one of these CRAs. On this, the adverse notice that you're giving to the person, so you've got the pre-adverse notice before, that has to be in writing, but then the adverse notice, when you're telling them, sorry, based on what we found and everything, that can be written, oral or electronic. So writing is always good. I don't recommend oral. If you do oral, I would follow up with a writing. Disposal. Here are the disposal. Everybody wants to talk about document destruction, right? I know I do. And next year in 2017, one of our topics. So we're putting together our topics for 2017, and those should be out in the next month or so. Well, certainly the next month. And one of them will be, so little foreshadowing, one of the topics that we're really excited about putting on is a document retention. So I can't think of a better way to spend an hour than talking about document retention rules. So I hope you're as excited as I am for that. So here's a precursor for one of them. What do we do with this background information that we're getting from the CRAs? So as most of us probably know, with anything having to do with personnel, hiring records, that sort of thing, we have to keep that stuff for 1 year. Applications and all that sort of thing. If you're a federal contractor, the Department of Labor separately requires certain employers to keep to keep documents like background checks and personnel records for 2 years. And then but then the FTC, you know, they don't really care how long. So I mean, we have to keep this stuff at least a year for most employers. But then when you do destroy it, you know, if it's consumer background check type of information stuff that we get from a CRA, then you are to securely destroy it by pulverizing, burning, shredding, or destroying electronic information so that it cannot be reconstructed. And I really like that the FTC uses the word pulverize. So they actually use that word. I think that's fantastic. But this is information that we should not just be throwing in the recycle bin. This is information that should definitely be going into the shred bin, and I know most HR people are pretty good about doing that, especially, you know, those that are keeping medical records with PHI and everything in it. So consider these records to be similar. I think that's very common, but you know, for those businesses that don't have sophisticated HR professionals, just know that you should be shredding and pulverizing and burning and destroying all this stuff so that it cannot come back and be found and be used against people to steal identities and that sort of thing. All right. Somebody asked a question. Let me see if I can pull the question really fast. Well, I don't see it. Okay. I'll probably see it later on. Jumping over to discrimination. The EEOC does not want you to discriminate. At least this EEOC doesn't. So best not to discriminate against people. I had talked earlier about why that is, with the disproportionate number of people of color who are incarcerated and convicted as well as arrested. And so we need to watch out for any sort of policy that just paints a broad brush, whether it's a hiring policy or any other policy. It tends to be hiring, that paints a broad brush and will not consider people who have an arrest or a conviction record, just because, like I said, that disparately impacts people of color. What the EEOC wants us to do is to make a qualitative look into the circumstances surrounding somebody's arrest or conviction. Greater weight, much greater weight, placed on a conviction versus an arrest. Arrest is pretty hard to give too much weight to, as I had mentioned earlier, but you can in combination with other things. But I think just standing alone in arrest record is pretty tough to make much of a decision on. So what we need to do is, after we have interviewed and have a conditional offer of employment and we're doing the background check, and if something comes up, what the EEOC wants us to do is that if something comes up in that background check of a criminal nature or any sort of nature, but primarily we're talking about criminal nature here, that we are to look into the details of it. And the EEOC wants us to examine to determine whether or not that conviction or arrest is directly related to the qualifications for that job. For example, if I am a bank, and if the person, and I am going to hire somebody to be a teller, and they're going to have access to you know, money and that sort of thing. Okay, so if I'm a bank, and if and I've got lots of other laws that you know, govern regulations and everything that govern how I need to operate. Okay, so you don't generally, you're looking for, if you're at a bank, you are generally looking to hire people who do not have convictions for theft, right? So we definitely, we want to look at, you know, not hiring people who have theft convictions or dishonesty, you know, or convictions that get to the honesty of somebody. And so, you know, would we care so much? So for a teller, if you had a conviction of theft, that would make a whole lot of sense not to hire that person because they have a conviction for theft. If the teller has a conviction for a DUI, then how is it really related to the job of bank teller? It probably is not. So in that situation, but the key thing here is that we're examining it. So we're looking into these to really see what the nature of the conviction is, and then making a qualitative determination as to whether or not that conviction that the applicant might have has a direct bearing on their qualifications for the job. A DUI, probably won't have an impact on the person's qualifications for the job of bank teller. The same same level of conviction, let's just say felony conviction, for theft, to me, would. So, we would, somebody with a theft conviction, we're going to say no. Somebody with a DUI conviction, we might be more apt to say, yes, that doesn't impact the qualifications for the job. That's what the EEOC wants us to do. They are going to look at, so the EEOC and the courts watch for these three things. So is there a disparate impact based on color, race, religion, sex, national origin, that sort of thing? And I understand that we don't know, necessarily the color and the race and the religion and all that sort of thing of people who are applying for the jobs. I mean, I get that. I think the EEOC gets that. Hopefully our applications don't ask for that information. But that's why we have to watch to make sure that our policies don't disparately impact people. And I know I've mentioned this on webinars in the past, but it always sticks with me when I was listening to the EEOC, to somebody from Washington was speaking at a conference I was at, and started saying that the EEOC was looking into address discrimination because they had done statistical analysis and found that people, who are living in the inner city would be living on, avenues and streets versus people from the suburbs who are disproportionately white versus the people in the inner city. People in the suburbs would be living on like courts and ways and that sort of thing with different numbers. And so from the EEOC's perspective, they were looking into seeing that if we were asking for address information from applicants, if businesses could use that to just start weeding out people, assuming that they were living in the inner city and therefore of color versus people with long numbers and ways and courts and stuff, which they might be more safely assuming are Caucasian. So I don't think that got too far, but it was interesting, and that's the type of thing that they're looking for. So is the disparate impact, so number 2, is the disparate impact job related and consistent with the business necessity? And so we go back to my bank teller situation. A DUI might not impact the qualifications, or business necessity for that position, but theft would. So we need to understand that. If the employer shows that it is, can the individual challenging it show that there's a less discriminatory or alternative method available? Okay. Somebody seems to have asked a question. I don't do code words. Somebody's asked about code words. I don't do them, so no worries. We track, just so everybody knows, for like SHRM credits and HRCI, that sort of thing. We look to see how whether how long somebody has been on the webinar, and then we issue the certificates to those people who have met the minimum length of time for the SHRM and HRCI credit. They have, so I'll read one. We have a situation, a separate attachment. This is for the background checks, authorizing us to do background checks, criminal credit. We only provide the summary of rights if we're taking adverse action, which is fine. So it'd be best practice to give it all. No, that's fine. You don't have to do it, the summary of rights, until you take the corrective action. What about a pattern of arrest? Can we use that as a basis to make a decision? Example, stalking of the last 2 ex-wives and a landlord or female. And I mean, you can take arrest record into consideration. I don't recommend it. I think it's risky. If you have a pattern, I guess that's more persuasive, but there are a lot of laws that prohibit, they're like at the state level, that prohibit you from going on arrest record. I just don't think arrest record is supposed to is intended to be that persuasive. So I would be cautious, but at least you're looking into the details of it, and so it does open up. So in that type of situation, it would open up a conversation for you to have with that applicant regarding those arrests, and you can definitely ask about that stuff. So in Minnesota, you can only do it after you've offered so at the interview or thereafter, but and as well as a lot of states because of the ban the box rules, but that opens up a conversation for you to have. So that's what I would recommend, but it's hard to put too much weight into an arrest record. So if you see this 80%, for those of you that are unfamiliar, if the impact from the policy that you have, so let's just say you have a policy that you're not going to hire anybody with a felony conviction, okay, and you're going to do background checks based on that. If the impact disproportionately impacts 80% of a protected class, then that doesn't mean that you definitely violated the law, but that's going to be a strong indicator to the EEOC, and they're going to look into it closer. It's also going to come up in a lawsuit if you're brought into a lawsuit. That 80% threshold where people are proportionally impacted, by race or religion or that sort of thing. So that's just kind of a criteria that we look at. And so if our policy, just does a little bit of a disparate impact, it's a nice way of saying you have to be pretty disparately impacted to get that 80%. But I've seen a lot of situations where it definitely comes up, and then the EEOC will be much more likely to pursue an action against your company if the disparate impact on your policy is 80% or more disproportionately impacting people that are protected by Title VII, for example. Is the policy job-related and consistent with business necessity? So again, going back to my bank teller situation, where it definitely is the job, the theft does impact. It's certainly business necessity, but it is related to the job, whereas a DUI might not. With consistent with business necessity, it just might make the person the conviction might make the person on their face like unable to work for the company because of regulations or licensing requirements, that sort of thing. So we definitely want to look at these things to understand a qualitative look at them to understand whether or not they are impacting the job. So these are the green factors that we would then look at: the nature and the gravity of the offense or the conduct, time that's passed. So for example, if somebody has been more recently convicted of a crime that relates to the qualifications for the job, more recent is going to be more dispositive on the issue and will relate more to their qualifications versus something that might be 10 or more years old, 10, 15 years old, maybe happened when they were 16 or 17 years old and they're 35 now. That the EEOC is going to say, look, even though you've looked into this qualitatively and you've done a little bit of analysis, that's pretty far out there. That person might have changed. We expect a little rehabilitation over time when there's been no other conviction. Now, it's going to depend on the nature of the conviction, the gravity of the offense. So we look at all these factors. So nature and gravity of the offense. I mean, if you've killed a child or something like that, even if you were like 16 years old and you killed somebody, hiring them to work at a daycare center, I wouldn't care how old they are. Probably the gravity is so strong that even though a lot of time has passed, you probably still don't want to put them in a position around children. These things all get looked at. And then the nature of the job or the position sought. And again, bank teller, we're going to care about theft and crimes of that get into like moral turpitude and that sort of thing. Versus if we if somebody, has some sort of other crime. So every job is going to have a different thing, and we're going to look at the qualifications for the job. So like I said, bank teller is going to have something different than somebody working at a light manufacturing facility, or somebody working at a law firm or an accounting firm. These are going to be different things. If we're an accounting firm, we don't want to hire somebody who has a conviction, I don't care how long, probably, where it's been some sort of conviction for honesty. We might not care as much if it's a conviction for something wholly unrelated to honesty, like a DUI or whatever, or maybe they got into a fist fight in college, right? And so we would look at that, but we might not care if they got into a fist fight and hurt somebody pretty badly in college, but we would care if they stole from their employer. And so again, we look at the nature, we look at the gravity, we look at how much time has passed, and we look at the position itself, because every position is going to be a little bit different, and every business is going to be a little bit different. And it's not, and I will say this, it's not an excuse to say we just don't believe in hiring people who have criminal histories. That's not, the EEOC is not going to let you get off like on that sort of argument. We need to look at why it's related, at the relation between the job, the time that's passed, and the nature and the gravity of the offense. We cannot just do a broad sweep and say we just don't like to hire convicts. It's going to be seen and argued potentially, at least by the EEOC and lawyers, it's going to be argued that that's disparately impacting people of color. Here are the recommendations from the EEOC. These guidelines came out a couple years ago, a few years ago now, so they're not brand new, but this is basically the guidance. Training, EEOC always likes to encourage training, avoid blanket exclusions, make sure you're looking at the job, what the qualifications for the job are, and then if you're doing criminal background checks that you really understand, and you can talk to the managers about what they're really looking for. A lot of managers don't want to hire anybody with a background check with a criminal history. They need to understand that puts the company at risk when they just broadly sweep aside everybody that has a conviction history. Need to look at what the conviction was for, how long ago it was, and how that is related to the job. And don't let managers just get away with saying they don't want to have somebody on their team that doesn't have any that has a conviction history. Are there less discriminatory alternatives available? If the employee is suing you, they've got to show that there's a better way than doing the background checks. This is just really more of a legal point than anything when we talk about burden shifting and arguments. So just know that the employee, they don't get to just say like, it's just discriminatory on its face. They need to show that, okay, there's a better way to get at finding out that the person had was convicted for theft, and for this bank teller type position. Okay, I've used this example in the past because I think Skeletor is pretty cool. So let's just do this. And I actually, part of the new thing format here, I'm going to do polls. I'm going to try to do this on a monthly basis and see who's still paying attention, although I think our reports that I get indicate that anyway. But so you run a fitness center. We're just going to pretend here. You run a fitness center, and you interviewed Mr. Skeletor and liked him, and he met all of the qualifications and seemed like a really nice guy. Lots of personality, lots of muscles. That's good for a fitness center. Background check, not good. So you've offered him a conditional offer of employment, credit card payments, hasn't paid his electric bill since 1983, conviction for jaywalking. Also, he doesn't like puppies. So that somehow ended up on there, probably like hurt a puppy or something. Manager you are having a second thoughts and you want to pull the offer. Let me send a poll. Let's see if I can do this here. Okay, I'm going to launch. Hopefully people can vote. Should be on the right side. See where we go. In the meantime, looks like there's a question. Oh, that's a really good question. Mr. Skeletor has applied for a fitness, like a personal trainer position. Okay, going to close it. Thank you all I don't know if I really do close it. I'll just say, okay, so we look like about 80%, 20%. And again, you know, we need to understand the position, right? So the position here is that of a personal trainer working with people. I would say, you know, some past overdue bills, not liking puppies, probably the worst thing, jaywalking, whatever. You know, it shows maybe some bad decision making, but if he's not in a position of having to make good decisions and walking with people and that sort of thing, I think you're probably fine. And it's been a long time since he hasn't paid his electric bill. So I would say I think I would err on this side, although he's, you know, evil looking. I do think that hiring Skeletor probably makes a lot of sense. Changes up here though, right? If we change some facts, and what if Mr. Skeletor's background check instead indicates an arrest for assaulting somebody named He-Man? Well, that's different, right? If he's a personal trainer, he's going to be working with people. Now, it's one thing when his background is that he didn't, that, you know, for credit card payments and electric payments and that sort of thing. That's more like consumer type stuff. Jaywalking, you know, not a big deal. But assault, well, that gets directly to what is the he's going to be doing for you as a fitness center. So he's going to be working with people, and so you would want to at least ask. So I think you would at least want what you would want to do here is at least ask. What were the circumstances for assaulting He-Man? Was He-Man a client of yours? Was this at work? What were the circumstances? And then based on the circumstances, you make the right call on Skeletor. But I think that one gets a lot closer to pulling the trigger and getting rid of him. Strawberry Shortcake, do another poll here. You manage a tennis center. It has locker rooms, hosts public and private lessons to kids, adults, etc. For all tennis instructors, you do background checks. Ms. Shortcake applied to be a tennis pro. The background check shows that she was convicted of selling an illegal narcotic. You poll the offer. Let's see what people think about this one. Oh, I don't want to do that. Okay, yes, here. Sorry about that. Let's see. Launch. Let's see what people think about Strawberry Shortcake. Convicted of selling illegal narcotics. She's going to be a tennis instructor working around children and families. Oops. I see. There we go. Okay. Great. So most people say no, and I think that's, you know, probably the right thing. You could look into it closer, definitely find out what the situation is. She sues, she claims new facts, right? She sues, she claims, she argues that your policy of not hiring people with a conviction history, dealing drugs disparately impacts people from Strawberry Land, okay, right? So a little bit different, we throw in those facts, but I want to move on because we have like 1 minute. And I want to show you, for those of you who are in states that have ban the box, right now, between all the 150 cities, counties, and all the states that have bans on ban the box, right now it covers about 200 million people living and working in those jurisdictions. Ban the box, for those of you who are not familiar in one of those states, ban the box, for the most part, these are at the state level, there's no federal law on this, prohibits you from doing asking about criminal conviction history until after an offer of employment has been made, or even not until the interview has occurred. So a lot of states have passed these laws. I believe Hawaii was the first one to do it. We've now got lots of cities and counties, major cities, counties all over the country that do this. So a lot of you as employers are pretty familiar with ban the box. But to the extent that you have on your job applications right now, the question that asks about criminal conviction history, please make sure that you're not in one of those states, cities, or counties that bans that sort of thing. It's been occurring in the last several years. Here are some other cities. There's even one in Texas. Even nobody's surprised, it's Austin, but even Texas prohibits employers from somewhere in Texas prohibits employers from asking about criminal conviction history before an offer of employment or before the interview has been made. So definitely check, review your applications, make sure the ban the box, like I had said at the beginning, is the weapon that employers are using, that states are using, and advocates against disparate impact discrimination are using to try to stop employers from not hiring minorities because of criminal conviction histories. Okay, that's it. I went right on time. Let me send out a poll. I hope, we'll see what people think. I'll be curious on your opinions of the new format. I do appreciate your questions and your attendance today, and if you have any further questions, you're definitely welcome to reach out to me or any of the other attorneys at Thompson Co. My information is here. Thank you, and I will talk to everybody next month when it is on the new way on what to expect, an overview of wage and hour laws. So everything you need to know about wage and hour laws is in December. Thank you.